When planning these events, we try to tailor the topics and the speakers to your needs. Full bios of the speakers today will be available on Eventbase, and that's the convention app, where you can see all the work that these folks have put into gaining the knowledge that they're going to share with you today. So please give them your full attention and be open to the information that they are presenting so that you can apply that back to your municipality. Some lessons are going to be easier to apply than others, but I'm sure that everyone in the room can use some of the valuable nuggets of information when you get back to your offices. This session is sponsored by True Green Energy, and we have Miguel Cantelier, President and CEO, here to, on their behalf, to introduce our panelists. So please show your thanks for sponsoring this session.
Thanks very much, Dale. It's our pleasure to sponsor this session today and address community leaders such as yourselves at the 113th SUMA conference. My grandpa was involved in municipal government for the better part of 5 decades. My dad was also involved in municipal government, so I know that trying to move a community forward and take on new, progressive, aggressive projects within a budget, and at the same time trying to keep all your constituents happy can sometimes be about as easy as juggling hand grenades. And so with that in mind, True Green Energy rolled out a program that I'd like to chat with you about today. True Green Energy is in the solar business, and we're rolling out a project called our Municipal Green Energy Program. This project is designed to allow communities and towns to go renewable without having to put the money up to actually build the infrastructure yourselves. Because of the unique combination of Saskatchewan being the highest producing place in the world for solar, one of the highest producing places in the world for solar, while at the same time being the second most expensive place in Canada to purchase electricity, towns and municipalities are able to lease these systems at a price that is actually lower than what Sask Power is charging today. So it allows you to do 4 things. Number 1, it allows you to offset carbon emissions with a green energy source. Number 2, it allows you to save money for yourself and your constituents. And number 3, it allows you to lock in energy costs for the next 20 to 25 years. The town of Lumsden has taken a real leadership role when it comes to this program, and they've been on the program for a year now. And so we're going to be doing a limited amount of systems per year. There's more information on most of the tables, I hope. I think we put some information down. You can also visit www.truegreenenergy.com. That's true with no E on it, just trugreenenergy.com to get more information. And myself and Pat, our VP, will be around to chat about that. But without further ado, that's not why you guys are here. It's my pleasure to introduce Bonnie Chambers, Senior Advisor with the Advisory Services and Government Relations, Rodney Audette, Administrator for the Village of Bethune and RM of Dufferin, Michael Solowan, I hope I said that properly, partner with Brownlee LLP, specializing in municipal law, and Malcolm Eaton, former Mayor of Humboldt and SUMA VP for Cities. Thank you very much.
Thank you very much, Miguel. I'll be moderating this panel, so please, if you'd like to line up at the mics and speak clearly for the purposes of the recording equipment, we're ready to take some questions. So don't run, we've got a little bit of time. I'll maybe start it off with asking a couple questions. Can a council change budget mid-year? Anybody want to tackle that one?
Why does everybody look to me? I'm not sure why everyone's looking to me to answer this one. So the answer is yes, council can amend their budget. Council would then adopt an amended budget.
Thank you very much. So when can a council actually hold in-camera meetings? Malcolm, maybe you can.
There's some provisions within the acts that allow council to hold in-camera meetings. Sometimes I find in talking to colleagues, there's sometimes some confusion over in-camera versus committee of the whole. And but there are reasons for which you want to have basically a private meeting, which is council or council and CAO or council and individuals you would like there. Personnel issues, contract issues, some of those kind of things that require a particular type of discussion that you want to be confidential. And of course, no decisions can be made within that context. Decisions are always made in an open council meeting. So I'd invite the other panel if I've missed, and if somebody wants to comment on the difference between in-camera and committee of the whole, I'd appreciate it too.
Perhaps I can speak to that. So first on the issue of in-camera, there's basically two broad exceptions under the Municipalities Act. The first is any matter under Part 3 of the LA FOIP Act. So those are the references Malcolm made to personnel issues. Other examples would include what they call advice from officials, local public body confidences, law enforcement matters, solicitor-client privilege, so your legal opinions. And then there's also the exception under the Municipalities Act for long-range or strategic planning. So in-camera is the exception to the rule that you have to hold your meetings in public, because the public has a right not only to know what decisions you're making, but also to observe your deliberations and see council in action. The committee of the whole is something that's misunderstood, in my opinion, by many councils who confuse a council committee established by council with what we call a procedural requirement under parliamentary procedure, like Robert's Rules of Order. So if you look at it from a parliamentary procedure perspective, committee of the whole is simply a more informal discussion that doesn't follow the same formalities of your council meeting, whereas committee of the whole, being a council committee comprised of all councillors, is just that, a council committee, whether it has simply advisory powers or decision-making powers based on the terms of reference for the committee.
Thank you very much. I see we have somebody at microphone 2.
Somebody's short. I'm Mayor Dave Summers from the town of Radisson, Saskatchewan. My question, with just a short background, is what is our recourse as a council when we've had a gentleman escorted by the RCMP out of our meetings? We've had to make a motion to ban them. They continue to come to our office. They continue to email myself and my administrator 8 to 10 times a day. They're emails that are basically slanderous and libel about myself and about our council. I actually had to phone the RCMP. The RCMP have been at our council meetings since November to keep order. This gentleman threatened my life. He threatened to kill me in our office. I had 2 witnesses, our administrator and a lady we'd hired to help with the books since the old administrator left. Both signed statements. I signed a statement. The guy left the office because the RCMP took half an hour to get there. The RCMP phoned me a week ago, or a week and a half ago, when I was in Mexico on a vacation, to say that they finally went to talk to him because he always gets too upset and screams at them. That was over a month since he did it. What is my recourse? Where's my protection when I have to look over my shoulder every flippin' day that I'm at home, wondering if it's going to be when? This gentleman is mentally unstable, which he's threatened to sue me over saying. He keeps calling us to take him to court, to sue him. He swears he's only out to save the town. He has phoned Government Relations Department, the Ombudsman, every department of the government you can talk to. He had the health inspector call us saying, because he said we were poisoning everybody with our water. This goes on and on. Today, sitting here this morning, I got 2 emails from him going on and on. What's my recourse? Our lawyers are trying to gather enough information to get a peace bond because he won't listen to our motion. The police think we're mistreating him. Like, what's my recourse? I'm confused. I really am. I feel unprotected in my own hometown that I'm the mayor of.
Thank you. Who wants to take that one?
Michael, sure.
Mike?
Take that one?
Mike?
I don't blame you if you don't.
I felt a lot of eyes burning in the back of my head here. So, well, a couple things. First, I'd say that the issue sounds serious enough that I'm glad to hear that you have some lawyers looking into it. Maybe we can step away from your specific instance and talk about some general principles that are going to apply to all the folks in the room here, and we can build from that. So first, because you're a local public body and your property is public property, the public has a right to attend your council meetings. They have a right to attend at your office and be out and about in town and in your park spaces. Those rights stop, though, when people cross certain lines. You mentioned defamation or slander. So if false statements that impact your reputation in the community are being made about you by anyone, then any individual would have a personal civil claim for defamation. That's a process to take, but not one I typically recommend just because of the time and cost and ultimately what do you get out of that. Some lawyers made some money and we tied up the courts. More practically, though, if you're talking about threats of physical violence, then we're looking at things like peace bond or a restraining order and working directly with the RCMP or your local municipal police service and the Crown prosecutors. Beyond that, there's also some powers for municipalities to impose time-limited bans on access to facilities under what we call petty trespass or trespass to premises legislation. Municipalities have to be very careful about using those types of powers. It's not the same thing as banning someone from your store or banning somebody from attending at your home, because the default rule is you have public property. And so there's been recent appeal-level court cases in Eastern Canada and Ontario where the courts have set a very high threshold where you have to not just have somebody that's annoying you or bad-mouthing you or causing distress for your staff, but rather that there are real and present dangers, threats of violence, which is also difficult to really nail down when we're dealing with people with mental illness. So those are some of the tools. Of course, at your meeting, your presiding officer has the ability to remove anybody from the meeting. And indeed, if the person's showing any kind of violent tendencies, you'd like to have local RCMP or municipal services, police services there to assist with it. But those are a couple of the options that are out there. We have to respect the public and even the public that wants to protest against council and what administration is doing. But when they cross the line into defamation, threats of violence, slander, you have a duty to protect your own employees under health and safety workplace legislation, and that's where you have to take some positive steps. So I'd refer you back to your legal counsel on that to pursue that further.
So if I could, I certainly have never had an experience such as you have described, and you know, my heart goes out to you because of the journey you're on here, which is very difficult and very painful for you personally, and no doubt for your council and your community and your staff. The only thing I would add, and I think Michael's described it extremely well, is document, record, record, record. I've had a couple of situations where people were somewhat abusive, disrespectful, whether to me personally or our staff or whatever, and that's certainly a very important piece, is to document. You're on a journey, it's going to end sometime, and you've got to make sure you've got all of the information to help the legal process unfold. So I would encourage you to, it sounds like you're doing that, I'd encourage you to continue.
Thank you. That brings up another question. Can a council ban a citizen from a council meeting? Anybody else want to take that?
The legislation allows the presiding officer, and Michael talked about this, that the presiding officer can expel a person for improper conduct. To ban permanently, I'm going to have to defer to my legal learned colleague over there.
Yeah, we'd be looking at exceptional circumstances to get a blanket ban because, again, one of the most fundamental aspects of democracy is the right of the public to be present at your meetings. So you'd be looking at that from a case-by-case basis. the duties under, or the powers under the legislation for the presiding officer to remove somebody, in my opinion, that's interpreted for inappropriate conduct at that meeting. If you're going to ban someone from council chambers on an ongoing basis, I'd recommend that you need a court order where a judge has made a determination that that's in the public interest. Otherwise, you run the risk of presumably a complaint to the Ombudsman's office and perhaps even the province questioning the practice. Because we want to make sure we don't abuse that power and start limiting access to people who we just simply disagree with. Ratepayers groups, folks that have contrarian views. And that's a fine line when you're filled with the emotion of having those folks beating you down every day and sending inappropriate emails and phone calls and harassing your staff.
Thank you very much. Microphone 3.
Good afternoon, Connie Henning, CAO for the town of Elrose. Please excuse me for asking questions again, but I'm a fairly new CAO with a very new council as well, so I'm hoping you can give some clarification. If you have a disruptive session of council and your mayor is unable to control it, what are some of the possibilities that my other council members might be able to do to help calm a situation in a council meeting?
In extreme cases, someone could adjourn the meeting and then it's done, and council could hold another meeting later, given proper notice. Outside of that, training in dealing with difficult people, that type of training, I guess, to calm it down. Rodney?
Well, I would think that you could go to your council procedure bylaw as well. If there's a contravention of an action of a councillor at a meeting, it could be called into question at that time. And then, like Bonnie says, you've got the option, or the chair has the option of calling for an adjournment, which of course is not, anybody does, right? Can call for an adjournment, which isn't debatable, and then if that question is called and carried, then a meeting could be rescheduled again with proper notice, given time for a situation to maybe diffuse itself.
Just add to that, another option as well is it's quite disruptive if you have to adjourn and schedule another meeting. Sometimes simply recessing, taking a brief recess, is enough of a reset for people to go out in the hall, blow off some steam, take a break, have a smoke, get a drink of water, whatever they need to do to calm down. And a brief recess can allow that meeting to potentially still continue on without having to schedule a special meeting or adjourning to the next regular scheduled meeting.
And that could be done by any councillor?
Unless there's something in your council procedure bylaw that limits that,
Yeah.
as general, yes.
Thank you.
Good, thank you. Number 2.
Hi, Ames Leslie, Mayor of Battleford. Question and of more of understanding. We all understand enforcement of bylaws and fines with the municipal level is tough within the province of Saskatchewan. So more or less looking for an update on how the pilot project of the municipal court is going. I don't know if Bernie Morton's here from Kinnersley still, but I know he was part of that.
That I'm going to have to refer to Sean. I don't know at this point. I know we talked about it a little bit this morning, but unless somebody else has anything on that. I know it was a resolution, I believe, to SUMA a couple of years ago, and if you can, if you want to bring your name up to me, I'll find out for you, or I'll have Sean contact you, and he can give you the answer to that. Sorry, I can't help. Microphone 2.
Hi, Marion Fairstead, Deputy Mayor of Radisson. So our mayor has already told you about this lovely gentleman that we're dealing with. He is asked, since he's been banned, he is asking to come back to council and talk to us again about things that he's already talked to us about. So our mayor has told him, you're banned, you can't come back. So now what he's done is he's getting his 17-year-old stepson, who's never asked for any information from the town office or any of us, and he's wanting his 17-year-old stepson to come to a town council meeting and to address us. Is this allowed? We don't know if we should be allowing this 17-year-old boy to come and talk to us. We need advice.
That would depend on your council procedures bylaw. If your council procedures bylaw has stipulations as to the age that a person can address council, or,
I don't believe there is.
yeah.
There's no age that
I get-
it says, yeah.
The other thing would be the number of times something could be brought back to council.
Do you have a time limit on, for delegations that come before council?
5 days. I'm sorry? Oh, yeah, sorry. Yeah, 15 minutes. So just let them talk? Yeah.
Yeah, there's nothing, subject again to your procedure bylaw saying otherwise, there's nothing prohibiting anybody coming, even if they're potentially coming on behalf of somebody else as an agent. It's going to depend on the content. And if your bylaw doesn't have an age requirement, and in fact some councils have youth members, then there's nothing that prohibits a youth who's almost at the age of majority in any event from attending at your council meeting. You're just going to want to monitor the presentation the way you do with all delegations of people coming back. Recognizing, though, that at the end of the day, I mean, folks, the general principle is they have a right to attend your council meetings. They don't, as of right, have the ability to present before council whenever they want and for whatever reason they want. That's how you set up your rules around delegations and submissions, and not keep rehashing the same thing over and over again.
Okay. Thank you.
Thank you. Microphone 2 again.
Rod Perkins, Mayor of Kindersley. I just was going to comment on the bylaw court that previous question had asked there. We are the test project, I guess. I would report that we've had 2 sessions already. We've got, I think it's somewhere around 40 municipal bodies that have joined in with us, and it's been quite successful.
Good. Thank you very much. Number 2.
Yeah, just to clarify something, I think we're not a whole lot different. I'm from Kenora. I don't think we're a whole lot different than a few other towns around. We've had a lot of new faces come on to council the last election. I'm one of them. Is SUMA looking at changing things a little bit? Like you're talking about having radical taxpayers show up at meetings. We've had one of our councillors get suspended twice in the last 6 months. And I'm told that if it's elected official, we cannot literally kick them off council. Is that true? We just kind of have to ride out the storm? Like with what they're saying from Radisson, that's just about to the point that one of our councillors is like that. And how do you deal with that?
Okay. It's not SUMA, so I'm going to refer the questions to my colleagues here.
No, as council, you can't kick someone off council. However, there is in legislation under section 147, it talks about disqualifications of council members. If the council member in question contravenes any of that, the legislation says that he or she must resign. If they don't, there's opportunity for a voter or for council to take the matter before a judge and have the person removed. That's what the legislation says. And I'm going to defer to Michael. I don't know if there's anything else that would be in civil law or common law on it.
The only other thing that comes to mind is to the extent that council could ask the ministry to conduct an inspection or inquiry into the conduct of one of its elected officials. Now, that's a fairly extreme measure, and one I'd always caution clients from doing unless they're understanding what they're getting into, because you can open that door, but you don't get to choose which rooms people get to walk through, so careful what you wish for.
It kind of reflected our situation, because when they said that they got their 17-year-old son coming, well, our councillor has his wife and his grandmother and his mother, they're all coming to council chambers with the same problem, and it's just...
To observe council or address council?
To address council, yeah. It's just,
And there again, it would defer back to your council procedures bylaw.
right.
As we had talked about earlier, whether there's the number of times something can be brought before council. So,
Thought maybe a 3 strikes, you're out, Paul.
no, no. And what Michael talked about is extreme situations when it comes to appointing an inspector, an inspection or an inquiry or any of that. Yeah.
Thank you very much.
From a number of these questions, I think the common theme is that council owns the agenda. Council sets the council agenda for meetings, and council controls how those meetings are run. The public has a right to attend and observe outside of the public hearing process, and their ability to present as a delegation or make submissions is subject to the rules you set up for them with your procedure bylaw. People shouldn't be coming at the last minute as delegations without prior notice, without council knowing what they're coming to speak on. And people don't have to keep coming back like it's Groundhog Day to say the same thing over and over again. Once council's heard the matter, considered that input, and decided to approve or deny a request, you move on. And if they're not willing to move on, then council can deny the request to attend again as a delegation. And if that's not what your procedure bylaw does right now, or not how you are using it, then you may want to look at, as a council, at updating it or changing your current practices.
So in my experience, in our situation, our procedure bylaw allowed for 15 minutes for delegations and required them to be make their request to be a delegation within a good period of time before the council meeting. We also required them to submit a document that basically outlined the ask or the information they wanted to bring to council. So we had a pretty good idea of what was coming to us. So I would recommend you take a really good look at your procedure bylaw in the spirit of, you know, the democratic process. You're not trying to limit people from coming and presenting to you with their views, their ideas, their concerns, but you are trying to make an effective meeting and an effective council. And so I think the procedure bylaw is a very important piece in response to some of these questions, and there are certainly councils around that have worked on procedure bylaws for various reasons, so I would encourage checking around what other communities have done and bring it forward to your council and perhaps, you know, improve or expand or put a little more grit into your procedure bylaw.
Thanks, Malcolm. Number 4?
Borden, pardon me, Borden Wassilick at the Resort Village at Candle Lake. I'm the mayor there. I have a question about attending meetings by electronic means. In other words, by phone. They can be absent, they can phone in from Portugal or Northwest Territories or whatever, and we have that exact situation. It's very disruptive and hard to conduct a meeting when you have that. And what I propose is that we change our procedure bylaw and I guess eliminate that ability to do so. So now, I brought that up and one of the guys says, well, a lot of us run because we understood that we could attend a meeting by electronic means. I want to stop that. It's in our procedure bylaw. Can we amend it without any problem or any comeback?
The ability to hold meetings electronically is at the discretion of council.
Right.
So it would be a council decision whether or not that they would allow that.
So there's no legal comeback if we decide to cancel that privilege of attending a meeting by electronic means.
If council decided that and amended their council procedure bylaws to reflect the council decision, then yes, because it is a discretionary authority of council.
Okay, thanks, Bonnie.
Yeah.
Thank you. Number 2.
Thomas Fink, Resort Village of Canada Valley. That was a nice segue to my question. Our administrator has the ability to go south this time of year, and who can blame him? Who is qualified or who's allowed to take minutes in his absence?
Bonnie?
I'll take this one again. Thanks for the question. Council can appoint an acting administrator for meetings, whether it be one meeting for up to 3 months, but that person could be the one to take the council meeting minutes. Okay? you would want to make that appointment probably, I would suggest at the beginning of each meeting that the person is there. How long does your administrator go away for, sir?
3 months.
For 3 months. So 3 meetings would be held then? Is that right, or do you not hold? Okay. So I would suggest, hey, obviously I'm saying something wrong because there's lots of rumblings going on here. But I would suggest you make that resolution at the beginning of the meeting that Bonnie Chambers is the acting administrator for this meeting and shall record the minutes.
Thank you.
I think the rumble is because we'd all like to go away for 3 months in the winter time.
Exactly.
Advisors don't get to either, don't worry.
Number 4.
Mayor Beachy, I just want to get clarification on the question that was asked on if you've got a disruptive counselor in a meeting making false accusations, whatever it is, but just in general being disruptive. Now, was it my understanding, I just want to get this clear, that anybody can make a motion to suspend the meeting, postpone it to another day or whatever? Does it have to be voted on, or can just one person make the decision? And if it is one person, is it the mayor?
So again, it's going to depend on your council procedure bylaw and what process you have set up in there, whether, for example, the chair is given any authority to adjourn the meeting on their own, whether those motions are debatable. Typically, I'd find that you would still have to vote on the motion. But again, you have wide latitude in what local rules you adopt, and you're not bound by standard reference guides to parliamentary procedure and how you operate your meetings. I don't know if others...
Yeah, I was going to say that if you do follow parliamentary procedures, I believe that a motion to adjourn is not debatable. Correct, Michael?
It is not debatable?
Right.
Correct.
So if anyone makes a motion to adjourn, it's adjourned.
That's parliamentary procedure.
It's not debatable, but then you still have to vote on the matter.
Yes, you would
Yeah.
yeah.
Okay, thank you.
Thank you. Does anybody have a question for Rodney?
Why don't you add?
I do. Does Rodney get 3 months off vacation?
Yeah.
2.5. No, actually, I'll just add something to Bonnie's comments with regards to if a CAO or administrator does happen to, is lucky enough to take an extended leave for vacation. The administrator also has the authority to delegate some of his duties. So if council has to give the authority, but the administrator can make a recommendation for that. So if the administrator would like to delegate his authority to the assistant to take the minutes while in his absence, that can be done as well, and it should be recorded through a motion.
Thank you. See nobody at the, I'm sorry, number 1?
I'm going to comment a little bit on the disruption at council meetings, but I'm going to change it to and go back to the very first question afterwards. So I got the sample bylaw council procedures. So it does say in here that, if there's an unruly member of council and there's the mayor or the reeve can order the member to leave, it has to go to a vote, but if it votes, then they're supposed to leave. That's under section 46(2) of the sample bylaw. Anyway, I want to go back to the budgeting question that was asked at the very start. So, and this is for Bonnie, this is the the administrator's corner in the monthly updates that come out on the internet. There was something that came out in January, and I got a couple of phone calls about it too. About it, the way it's worded, it's almost like it's saying that you should amend your budget on a regular basis. And my way of thinking about budgeting is that it's your plan at a point in time, and then if you just keep amending it, you might as well just pass your regular financial statement every month as your budget. So it's just the wording of it. It's like you're supposed to amend it on a regular basis, and to me, that's not really the planning tool that it was supposed to be used for.
I think we just put that in there to test you. honestly, no. I believe what it said, and I don't recall what it said, but we probably said to review it and to keep tabs on your budget regularly, and to review whether or not the council, the municipality is within their budget, and if they find that there's one area where they have a lot of changes made, they may want to amend it. At least that was the intent that we had. Obviously, we didn't word that correctly because it was misconstrued. So.
Thank you. Thanks for clearing that up. Microphone number 4.
Hi there, my name is Audra. I'm the new councillor for the town of Asquith. Coming into the council meetings, I've discovered that there's quite a few nuisance properties around our town that we're trying to work on cleaning up. But we've also discovered that there's not a lot that we can do to encourage these people to clean them up. And we're running into a lot of beautification problems, I guess you'd say, with our main street not looking as pleasant as we'd like with these nuisance properties. What would you guys suggest that we can, another step that we can take to encourage these people along?
Bonnie?
The legislation, Section 8, allows council to pass a nuisance bylaw to deal with nuisances. And what that does is that council can issue an order to remedy, and if that person doesn't do it, then council has the ability to see that the work is done, and the cost of that work could go on that person's taxes. Okay? We have a sample guide, sample bylaw on the website for that. So that's what they could do.
Okay. These particular people, we've have the nuisance bylaw, we have all of those steps. We've actually had to bring the RCMP in on several other occasions because some of the gentlemen get combative and aggressive towards council or anybody who tries to deliver a notice or get the work done. And we're hands tied because RCMP are saying we got to go to the provincial government. The provincial government's going, well, it doesn't fall under our stuff, it's your stuff, so.
Michael, got any solutions?
Yeah, the other method would be working with your solicitors and potentially pursuing a court application to get a court injunction, which then would give the RCMP some further tools to deal with the matter and allow for your forces to come on and do work under the supervision and protection of the RCMP. And failure to comply with the court order could then lead to another court process where you're actually going to court for an order of contempt. The judges really don't like when people don't follow their orders, so that can carry with it additional financial penalties or even incarceration in some circumstances. So if your nuisance bylaw, ticketing, or orders to remedy aren't being followed, then your next legal escalation would be to the courts.
Perfect, thank you.
Thank you.
Thank you.
Okay. So if I declare a conflict of interest, do I have to leave council chambers? And can I just sit back and abstain from voting or let the other members vote or make decisions on my behalf?
Yes and no. So the way I always try to have people remember it is declare and depart. So the concept is if you have a personal interest, whether it's financial or not financial, that you can't be part of that decision because the role of elected official is to deal in the public interest, not personal or private interests. So as soon as that matter is raised on the agenda, get the attention of the chair, declare your interest, the general nature of it, disclose any facts that you need so that people understand what it is, and then physically, literally get up out of your seat and leave the room. The concept is your mere presence in the room. I know it sounds like a crazy formality in some of your smaller centers. Maybe you're stuck out in the hallway or you're even outside freezing, waiting for the next agenda item. But if you're in the room, even your nonverbals, even your mere presence there can be perceived as attempting to influence other council members, and so you really need to be out of there. There are a couple of limited exceptions where you can remain in the room, but they don't happen very often, so the key principle to remember is to declare and depart.
The recording officer, the administrator, should also, within the minutes, record the time of the departure and the declaration, as well as after the decision is made, the time that the council member comes back into the meeting.
And to Rodney's point, as an elected official, at the next council meeting, when those minutes are presented, make sure that you look through them and ensure that they accurately recorded your declaration, the time you entered, left the room, and the time you returned. That's your best evidence if an elector ever attempts to take you to court for disqualification.
Number 2.
Keith Matheson, Town of Birch Hills. Just as to expound on this a little bit, when you have your motion to pay your bills, if there's one bill within 50 that pertains to conflict of interest for that person, do they have to leave for the whole financial discussion of the accounts payable?
Right.
Or do they leave and council discusses that one bill and then they come back for the rest of the discussion?
All right.
Depends. We do get this question once in a while, and what we often tell administrators is, when you know there's one bill that's being paid of where a member could have a conflict of interest, because it's not up to the administrator to determine, you might want to have that payment made separately, you know, or you as a council member could ask the administrator to put that separately so that it's in a separate motion, would be one thing that we would suggest, okay, if you know of it.
Thank you. Anybody else? Oh, I thought he was moving to microphone 1.
Number 2.
Thomas Fink.
Oh, number 2, sorry.
Number 2, okay. I just wanted to add that our administrator is still working on our behalf. It just happens he's doing it from Phoenix. He's not physically there for the meeting. That's,
Is he sending you questions?
yes.
Oh, okay.
Okay, number 4.
Just on that one with the conflict of interest on accounts. Now, can we get just a quick review of that conflict? Because in a lot of cases in small communities, you could be related to a lot of people. So like that could be a long way back. So can we get a clarification on if a member of council is father, cousin, or such?
But Byron, if it's a financial conflict, it's always a conflict, okay? So I think what you're referring to is that when it comes to conflict of interest or a closely connected person is the spouse, dependent child. That's it, yeah. And good thing you know my legislation. But the legislation does say a financial conflict of interest is always a conflict. So if you or a member of, or a closely connected person, meaning family, employer, business partner, could benefit or be adversely affected by a decision of council, it is a conflict of interest and you must declare it. I'm not sure if I'm answering your whole question or, okay.
What happens if it's my brother-in-law that has the business and I'm on council? I don't have a financial interest, but
there's also the perceived conflict too. So that wouldn't be a direct conflict, so to speak. Possibly, I don't know all the situation, but there's also perceived conflict. And a lot of times we might suggest that a council member may want to, like if you're in doubt, declare it and depart, okay? And then there's no question. However, legally, when it comes to the closely connected person or being a family member. Michael, have I covered it all, or do you want to add anything to it?
No, I think that's it. I mean,
Yeah.
the definition of family is fairly narrow.
Narrow.
Recognizing that in a lot of communities, if we cast that net too wide, you couldn't conduct your business.
Yeah.
Right? The important thing with conflict, though, to note is it's not a dirty word. If you have conflicts, good for you. It means you have family and friends and a job and business interests. So it's not a negative thing to declare. It's simply about not only ensuring that we're acting in the public interest, but that the public perceives and observes and believes that we're acting above reproach. So that's why the standard's set so high, to keep people out of it. And typically, there's enough other people around the table to make the right decision that your presence isn't going to make or break the day. So why expose yourself to potential liability or even disqualification?
Good, thank you. Microphone number 4.
My name is Kendra. I'm from the town of Capella, councillor. I sort of have 2 questions, maybe. One is, can anyone else declare a conflict of interest on my behalf? Can someone tell me that I have a conflict of interest, or do I have to self-declare that?
The onus is on you to determine whether or not you have a conflict of interest. There might be something in your Code of Ethics bylaw that says as council members, we're going to, maybe I might suggest to Rodney that, he may have a conflict, he may want to declare. That could be in your Code of Ethics bylaw. But bottom line is, the onus is on you to declare it.
So just so I can have this completely clear in my mind, at one of our council meetings, our mayor decided something was a conflict of interest. And when we had expressed that that is not, we were told that as mayor, he has final say over what is and is not a conflict of interest.
No, I will repeat and say that the legislation is clear, is that the onus is on the council member to determine whether or not you have a conflict of interest. I may not know that you have a conflict in a matter that comes before the council. Therefore, you would just make that declaration and leave.
Okay. Thank you. I don't see anyone behind me. I would like to know what the protocol is when a member of council shares a conversation or shares information that goes on during a closed session with someone outside of that closed session before that topic is brought up at a council meeting.
It could be addressed in your Code of Ethics bylaw. Section 92 says that no member of council shall discuss anything until it comes before an open meeting of council. However, the only sanction would be the Code of Ethics bylaw, unless I don't know. Rodney?
Yeah, so that your Code of Ethics bylaw would be your first place, because that would definitely be a breach of the bylaw. You're breaching the Municipalities Act by doing that. Depending on the nature of the information you're sharing, there could be exposure to civil liability if you're disclosing personal information of a third party. That could bring the Office of the Information and Privacy Commissioner to have interest in that, or the Ombudsman. If you're disclosing business information of a third party or impacting negotiations on a pending transaction, you may end up getting sued for loss of business profits or lost opportunity if you've now disclosed things you shouldn't. So it's not just the principle of we have to keep things confidential. The actual information itself could expose councillors to personal liability. They won't be protected under the Municipalities Act for those types of breaches.
And I promise, just my last question. The Code of Ethics applies to the mayor in the same way that it applies to the rest of council, is my understanding. And it's my understanding that if I as a councillor were to break the Code of Ethics, it's the mayor's responsibility to make that known or to make that decision. What if the mayor breaks the Code of Ethics? Who holds him responsible?
Not me. I can respond. I'm not sure it's a direct answer, but I think every council periodically has to have some conversations about how it operates. And there have been a couple of questions today that's making me think, okay, as councils, and in my experience from time to time as a council, you need to have a conversation about how you operate. And you bring to that conversation, what are the good governance principles we should be applying here to our work as a council? And certainly confidentiality is one of those. Respectful interactions is one of those. Appropriate decision-making is one of those. Lots of topics around that. And so I think that's something that from time to time, and based on my own experience, I saw the need to do that from time to time. Some councils I know, and we did it a bit in my community, where we did a bit of a self-evaluation, a council evaluation, where there's lots of good board governance questionnaire type things you can find, and you do yourself a little survey about how we're operating as a board. And as a result of that, that brings up the issues. You know, this is what we're doing well, but here's some things we need to work on, folks. So I think that's part of the answer. You know, councils need to have a conversation about how they operate, how they function, and what the good governance principles are. More directly in response, you know, that's the opportunity for a councillor to say, in the situation you described, we need to have a discussion about how we're operating as a council. So let's sit around and have that discussion. And that's where you bring up very directly, very honestly, but very respectfully, you know, I see this as a breach of the Code of Ethics, and we need to talk about this so it doesn't continue to happen, doesn't happen again.
Thank you.
Thanks.
If I can actually add a little to that, your municipality under Section 93(1) of the Act will have a Code of Ethics bylaw. I would suggest that read the bylaw over to see what's in there, because it is detailed enough that it provides for what your responsibilities are, it provides for the complaint procedure, and it also for contraventions, how to deal with contraventions as a council. So it should be in there.
Okay, one more question. We're running out of time. I think the gentleman over here has been standing there for a while, so.
Jim Glant, Mayor of Churchbridge. On the in-camera, we have a resolution coming up, and it came up as at a council meeting where a former councillor says, how do you get out of camera? He says, you make a motion to go in camera. So my administrator searched North America, and the best one she could find is in Manitoba. It's resolution number 14, and it's the only resolution you can make in camera is to come out of camera and go back into a public meeting. But they also have better descriptions of what and how you go into camera. My other comment is, with all these conflicts with disruptive councillors or the public. When I first got on council, our council meetings used to last 4 to 5 hours. I got it down to an hour and a half, at the most 2 hours. I can read, I'm pretty good at reading how the resolution is going to go, and the secret I have is table it. If you can't send it back 2 weeks later or a month later, you can discuss it personally, and then when you come back at the next meeting, you can solve it. Thank you.
Do we have time for one more?
Who wants that?
We can, I think it was just a comment, wasn't it?
Yeah. Okay.
Perhaps if somebody is looking for other resources or resolutions around clarity on in-camera, in Alberta, the Municipal Government Act just went through 3 separate bills to amend it over the last couple of years. And the process that's now mandated for municipalities in Alberta is that you have to have the resolution to go in camera, and that resolution has to expressly state the general nature of the issue that you're going to address in camera, and reference the specific section of the FOIP Act that authorizes council to go in camera, so that the public's got enough information to understand that you have a right to go in camera, and then they're assured that what you're going to discuss in camera is the item for which you're purporting to go in camera for. And then on the way out, you pass the resolution to come back to public meeting.
Thank you. I'm sorry we're running out of time, so I'm going to have to move on. I want to thank the panelists for their participation. We really do appreciate you taking the time out of your schedules to be with us today. And I have a thank you card for each one of you on behalf of SUMA as a token of our appreciation. And I want to thank our sponsor once more, True Green Energy, for joining us today. And remember, the presentations will be available on SUMA's YouTube channel later on this month. The resolution session starts at 3, so we have to get out of here pretty quickly, and it's going to be a very busy session. So with that, I'd thank you very much for your participation today, and we'll see you in a little bit.